The first thing we're going to talk about is contract terms. And hopefully you guys are thinking about how important contract terms are now. It's about leverage. And I mean, I have a lot of clients, I have a lot of friends who have this feeling that, you know, contract terms don't matter that much. I have a lot of clients who just sign whatever contracts ever sent to them and stick it in the file drawer and forget about it. And as a business matter, I can't argue with that. I don't know whether it's worth paying $500 or $1,000 every contract you receive to pay me to review it and revise it. I do think it's worth it to do that 2 or 3 times with a lawyer, because we will train you to review them yourself, because it tends to be the same subjects, the same issues over and over again. And after doing that 2 or 3 times, we can put you in a position that you can do it yourself, or maybe once every 5 contracts, you might run into something a little strange that you need a little help with or whatever. Contract terms, however, will not prevent all your problems. If you do business with the wrong people, you're going to have problems. And there's nothing you or I can put on this sheet of paper that's going to avoid that reality. And what I'm thinking of, I mean, I have some unsophisticated clients that's exactly their expectation. I have had people hand me a contract and say, I want you to review this to make sure I don't have any problems. That's an impossible job description. If your debtor becomes insolvent, you will have problems. Nothing in this sheet of paper is going to prevent that. If they are crooks, that sheet of paper isn't going to help you. If you supply the wrong project, you will have problems, which is really getting back to the 10%, 5% thing. I would really like you to have an awareness going into every project where you're about to send $100,000 cash. Am I going to be a secured creditor on this project? Is this project bonded? I think that's something you want to know going in. If the owner is a crook, your customer might be the nicest, most honest people on the planet. But if they're on the wrong project and the owner's a crook, or the owner becomes insolvent, everybody on that project's going to have problems. It doesn't matter how honest your customer is. All right, so do contract terms matter? I think they do matter. You have to decide as a business matter how much time and money to spend worrying about it and trying to change it. And I see clients really differ on that. And I do want to point this out. I have clients at every level, whether it's a supplier, a sub, or a GC. I have clients that insist on controlling certain bare minimums in the contract. I have clients who don't negotiate them at all and will sign whatever anybody hands to them. Clients really vary in that regard, and I'm not smart enough to know which one's smarter, but I want you to know there's a difference. And for all the debtors in the world, you will often hear, you know, you can't change my contract form. I won't agree to it. That's bull. It's not true. It depends on a lot of things. We're going to spend some time this morning talking about how you recognize the types of things people will typically change because it's simple and it's patently reasonable, et cetera. But for the purposes of this wide crowd with a lot of different people in a lot of different positions, let's just say this is absolutely true. Everybody will revise their contract to some extent in some instances, and a lot of my clients are pretty aggressive about their contract terms and requiring their contract terms. A lot of my clients are not. That really varies too, and it seems to work both ways. Contract terms are about leverage, cost, and risk. And it's really what we were talking about a few minutes ago. It's being at least the credit card guy and not the doctor. The doctor has no leverage. These are related concepts, and you can really put all of them together. All right, a good example of this is interest and attorney's fees, or service charges and attorney's fees. Service charge is really synonymous with interest or finance charge. Those are all the same things. Maybe service charges are a higher percentage, but they're really just all forms of interest. And I like to start with this example because the unsophisticated amongst you would think that the reason I'm bringing this up is because I'm an attorney, and attorney's fees are important to me. And yes, I'm an attorney, and attorney's fees are important to me, but this contract provision will actually work me out of a job. Absolutely true story. If you are able to get the contract term in your contract that the debtor is going to pay your legal fees if they default, you are far less likely to need to hire me to enforce that contract. There's no question about that. For starters, if there's any doubt in anybody's mind, a judge has no power to grant you attorney's fees unless the debtor has agreed in a written contract to pay your legal fees in the event of default. It doesn't matter how unfair it is. It doesn't matter how many times they promised you the check was in the mail. You will not get legal fees. That is the penalty you can make the debtor pay for making you wait 6 or 9 months. If I know you're the doctor and I can pay you $100 today, or I can make you wait 9 or 12 months, and I'm going to pay you the same $100 with no penalty, you're the last bill I'm going to pay, right? There's no, to put the same thing another way, if you do make what's usually a mistake, not always, I mean, stuff happens, but usually a mistake, if you agree to lend money and ship product or supply labor and materials without having a written contract, and you have no attorney's fee provision, that is the case that's going to go on 9 or 12 months. You're going to have to pay me to prepare for trial, and then they're going to want to settle at the courthouse steps for 80% of your principal, or maybe 100% of your principal. You'll probably take it. And you'll end up netting 70%. You know, your profit's gone. You're going to have to put together 5 or 6 successful transactions just to be even for that one that went bad, right? That's what you face if you have no leverage. There's no penalty that you can make the debtor pay for making you wait. Okay. Leverage, the ability to motivate the debtor to pay. Your costs, legal fees, cost money. How are you going to get those costs back? And your risk of default, and your risk of taking a complete loss are higher, or they're lower if you have this contract term. Okay, you can look at Appendix 1, and this is a good opportunity to do that. Appendix 1, second page, paragraph 2 is your attorney's fee provision. I think I gave you a separate handout of this proposal for labor and materials. It's paragraph 6. But all of the terms I'm going to show you in this section are in those appendices, so you might want to keep them open. You do not need to write them down. There's your Appendix 5. Appendix 6 is the supplier proposal. All right. In the same place on all those documents is the forum selection clause. This is getting, again, a little bit lawyerish, but again, I want to make the point that it's about cost and risk and leverage. Every contract I write, including the appendices that are in the book, says that if you sue me or I sue you, the suit's going to be in the county of Fairfax, Virginia. It says that because that's my regular court. That's the closest court to my office. And so if my client wants to sue a debtor, the cost is lower to my client if I'm allowed to go sue them in Fairfax County. Jurisdiction and venue, if I shipped product to Richmond, and that's where the debtor resides, in Richmond, I'd have to go sue them in Richmond unless they had a contractual agreement that I'm allowed to sue them in Fairfax. Again, just think about the difference in cost and risk. If I can sue them in Fairfax County, they have to decide whether they're either going to hire their lawyer to drive 2 hours each way every time we're going to court or we have a deposition, or they can hire a lawyer in Fairfax that they've never worked with before, which is also can be risky, right? So you have an advantage. The party that has that forum selection clause has an advantage. I can make the litigation more expensive for you and less convenient for you and more convenient for me. That's leverage, cost, and risk. A couple other tidbits. The first question is they agree to submit to personal jurisdiction in Virginia. If you ship from Maryland into Virginia, both states have jurisdiction. It is possible for litigation to be instituted in either state because the customer called me in Maryland to order labor and materials. That's sufficient contact with Maryland that the Maryland courts have jurisdiction, but then I shipped into Virginia. That's sufficient contact with Virginia that those courts have jurisdiction also. Suit could be filed either place, but you can contract your way out of that. Usually, you can get your debtor to agree that doesn't matter who files suit, it's going to be in Fairfax County, Virginia. Similarly, jumping ahead to reviewing contracts, if you're sent a contract that your customer wants you to sign for a project in Virginia, and it says any litigation will be in Wilmington, Delaware, is maybe one of the most common things you'll read, that's a problem for you. Do you want to hire a lawyer in Wilmington, Delaware that you've never worked with if you end up in some kind of dispute with this debtor? Doesn't that make it a little bit more likely that debtor is going to dispute something because they know you're going to have a problem if you have to go to Delaware to enforce your contract? Leverage, cost, and risk. Another little tidbit is that jurisdiction is different than venue, or forum is different. This last sentence is what you call a choice of law. This agreement shall be governed by and construed in accordance with the laws of Virginia. That's what you call a choice of law provision. A lot of people think that that means this will be heard in Virginia courts. That is not true. I guess that's the main point I want to make. The debtor could still sue you in Maryland, but the Maryland court is going to have to read up on Virginia law to figure out how to interpret your contract. Virginia law will control, but the Maryland court has jurisdiction to hear that dispute. There's a difference. You want your provision to say all of those things. Expressly agree to personal jurisdiction. I give the courts of Virginia the right to make me come to Virginia to litigate. The forum is going to be County of Fairfax. The forum is really a county issue within the state sort of issue. And then what law will control. And in this instance, all three of them are Virginia and Fairfax County, Virginia. It's either going to be where your office is or where your lawyer's office is, depending on which is more important to you. Okay. Breach, insecurity, and adequate assurance. We are generally going in order on Chapter 2. If some people prefer to flip through it that way, it may be hard to tell exactly where we are, but one point I want to make is that everything we're talking about is in here. Page 2.2 is the service charges and attorney's fees, and we're generally going in that order. Limitation of liability, exclusion of warranties, notice of breach is where we are now, 2-7. I have no obligation to perform. I don't have to ship until you show me that you're going to be able to pay. You might think that's a hard provision to get, but it surprises people to find out that this is essentially what it says in an AIA contract, which is a very common form that you will see. And it's one of the reasons you like an AIA contract as a creditor. If somebody wants you to sign an AIA contract, you're generally okay with that because it's pretty even-handed and fair. And one example of that is that not all AIA forms, but most of them say that you're allowed, before you even begin performance, you can say, show me you got the money to pay for this. Show me that your bank loan has been approved. Show me that you have enough cash to pay for this. But I would like to point out, in addition, that becomes particularly important in the event of change orders or delays or problems on the project. These are things that are increasing the budget. If a $10 million project is delayed 3 months because of some problem with the plans and specs, the budget on that project just went from $10 million to $11 million. Does anybody have that $1 million? Is the bank going to increase the loan $1 million? What's going to happen? Is the owner going to say, oh, well, I guess I got to throw another $1 million into this? Yeah, that's the beginning of a dispute. And there's usually a genuine dispute where different people on the project think it was the other guy's fault. It's the architect's fault, it's the GC's fault, it's the owner's fault. That's what it is. And what's the owner going to do? I guess there's no owners here, so we can go ahead and talk dirty about them. The owner wants their project done. They can't rent it if it isn't built, right? They can't sell it if it isn't built. They don't want to talk about whether they got the money. They're going to start sending you notices. You need to perform immediately, or you are in breach of contract. We got to get this thing done. But you as a creditor, I guess what I'm saying is it becomes very important to you to have the right to say, we're ready, willing, and able. We will be out there tomorrow morning. Just show me you got the money to pay for this change order.
Do you have any advice on what that looks like? What would they show me?
Oh, good question. Most commonly a letter from the bank, or I've had people give me financial statements. And it varies. I mean, you may be satisfied with essentially a financial statement that's showing dollar amounts that are in various bank accounts and the amount and the commitment for a certain loan. But that's a very good question because the quality of the information you get varies quite a bit. And you very well may end up with a business decision to make how hard you want to push. But there are instances, especially if there's reasons to be particularly suspicious, there are circumstances that it might be a deal breaker. And that's the point. It gives you the right to stop performance. Here's another example of the same related but different concept. You're allowed to stop supply if the money stops. I don't have to supply any more labor and materials if the money stops. Now, well, the thing I like about this provision is it's difficult to end up in a dispute about whether you have received money recently. What you end up in a dispute about is whether that's your fault or the debtor's fault that you're not getting money, or some third party's fault. But there isn't, if you think about it, I would respectfully submit to you, it's not really usually in dispute whether you've been paid in the last 30 or 60 days. And what I'm thinking of, what I was about to say, is a very common question from clients, or I hear clients say, well, I had this guy on 30-day terms and he's now been 70 days. I don't have to supply on the project anymore, do I? I'm pulling off that project. And my answer is almost always going to be, you better stay on that project. You better continue, because it's just too risky to do otherwise, unless you have this type of provision. Because the problem is, I think the best way to explain the problem is that I don't think there's ever been a construction project in history that was built exactly according to plans and specs or exactly according to schedule. Has anybody here ever seen such a project? It's chaos. That's one of the newsletters I sent recently. Construction is chaos. It is always chaos. It's such a human business. There's so many moving parts, so many things that can go wrong. And there are going to be problems, and there are going to be disputes about who caused the problem. And so, in other words, yes, the debtor agreed to pay you within 30 days. If the debtor may be in breach of contract for failing to pay you, maybe, in another 9 or 12 months, maybe we'll find out. But for right now, all we can do is agree it might be their fault. And if it is their fault and they should have paid you 30 days earlier, what are your damages as a creditor? Your damages are 1 month of interest at the legal rate of 6%. So you get a half of 1% interest for the fact that they delayed payment to you for 30 days. But if you pull off the project and the project's delayed for 90 days because they have to go find a different supplier, and it turns out you were at fault, what's their damage? You delayed a $10 million project 90 days. Their damage is a lot more than the 1% on the month. You have a damages problem. You're going to cause a lot more damage than you're going to incur by stopping work. It's too risky. Both sides can be at breach at the same time. I guess that's the best way to put it, that people need to understand. That's very common. In fact, I think it's basically the situation you're in most construction contracts. You are in breach of contract. They probably are also. Who's more in breach? That's what judges do for a living, right? But it's just too risky for you to walk off the job. Unless what this provision says, and I'd be nervous about doing it in a lot of instances, even if I had this, but this puts you in a much stronger position. What this says, the problem you have as a creditor, assuming, I'm addressing the creditors, and all of you guys are debtors sometimes too, and that's different. But as a creditor, you have a huge leverage problem. The debtor has your labor and materials. The debtor has your money. If nothing ever changes, they're fine, right? You got a problem. You've sent the $100,000 out the door. You don't know if you're ever going to get it. You lent money at this interest rate, right? You have a leverage problem, right? What this says is, if the money stops, if you stop paying me, I know I might be in fault, but we're just going to agree in advance, the work stops. And we're going to resolve that dispute right now before work starts again. Could you end up in fights about that? Heck yeah. But this is an enforceable contract term and makes it far less likely. The debtor has to worry a lot more about their ability to claim damages against you if they have agreed to this. Notice and an opportunity to cure. You must make sure it is in your contract. Again, we're still talking about the proposals. What we're going to put in our proposal that we send as a creditor, whether you're a supplier or a subcontractor or a GC, this is the way you want it to read. I think, and it is in all the appendices, Appendix 1, Appendix 5, Appendix 6. It's somewhere around page 10 is the discussion. One version this comes in is that they have to give you written notice of any claim of defect within 10 days after receipt. Another form this comes in that's also good, and I'll usually put both in, and these appendices have both, that you cannot back charge me for any type of defect unless you give me written notice that something's wrong, you let me see it, and you give me an opportunity to fix it. And if you think about it, the main thing this guards against is the situation that the guy doesn't pay you, they don't pay you, they don't pay you, you finally call me. Hopefully you preserved your mechanics lien rights. If you didn't, you're just suing on your unsecured contract. Now we're suing them. Now you get a list. In answers to interrogatories, they tell you the 12 things you were doing wrong and you were in breach of contract on this project, and that's why they didn't pay you. And you're like, wait a minute, this is the first I've heard of any of this stuff, right? Has that ever happened? These provisions keep them from doing that. So in some manner or another, they got to give you written notice of a problem with your performance. The written notice must specify the default, because again, you can receive default notices. I mean, I find it somewhat humorous. It's very common, but it's a problem. You'll keep receiving notices saying you're in default. You have to start performance immediately. I'm like, what? What am I doing wrong? I mean, that's very common. It's actually a pretty smart thing for a debtor to do, to just muddy the waters, keep sending you default notices without ever going out on the limb to explain exactly what you need to do to fix it. You want a contract provision that requires them to give you written notice, and it has to specify the default, and you are not in breach of contract until they have done those two things and you have failed to fix it within a reasonable period of time.
Contracts, we're subcontractors, so I'm reading GC contracts, where we are told that we have, that as part of signing that contract, we waive our lien rights.
Yes.
Is that enforceable?
Not in Virginia or Maryland. That's a good question. We're going to talk about that at some length in the afternoon. But the short version is both Virginia and Maryland now have savings statutes that's unenforceable. In D.C., you're at risk. So that's something to worry about. Most states, you are at risk. Okay, the trust fund statute. This takes a little bit of time, but I think it's worth it for a number of reasons. Maryland has a trust fund statute, which it's related to the mechanics lien code. We're trying to get a trust fund statute passed in Virginia right now. But this is how it works. The supplier supplies materials to the sub. The sub supplies labor and materials to the general contractor. The general contractor supplies those labor and materials to the owner. That's what I call the contract tiers. All right, now the money flows back in the other direction. The owner pays the GC. When that happens, what the Maryland Trust Fund statute says, when that happens, the general contractor holds that money as trustee for the benefit of their subs and suppliers on the project. And then when the GC pays the sub holds that money as trustee for the benefit of their subs and suppliers on the project. Why do we care? What difference does that make? Any thoughts on that? It does enable, for example, if the GC doesn't pay you, now this sub can sue the GC for breach of contract because they signed a contract with us. And in addition to that, you can sue them for breach of trust. They violated their obligations as trustee by failing to pay you. So that's a true story. And that could make a difference, but I'm not sure how much difference. If you think about that, either way, you're entitled to a judgment against the debtor. It's an unsecured promise to pay. You can go garnish their bank accounts, and if they have any money, you'll probably collect. But other than that, it doesn't make that much difference. Where does it make? There is a place that trust fund statutes make a huge difference. Any thoughts on where that is? Let's talk about, you can also have, that's the way the Maryland Trust Fund statute works, but you can also have trust agreements. You can put trust fund provisions in a contract. Indeed, if you look at Appendix 1 again, page 2, paragraph 5, customer agrees that all funds owed to customer, to the extent those funds result from labor and materials I supply, shall be held in trust for the benefit of seller. And you're not allowed to do anything with that money except turn around and give it to me. That is a trust fund agreement, and it puts you in the same position. The only difference in Maryland is that you're automatically in that situation if you're on a construction project in Maryland.
So are all construction contracts in Maryland trust fund statutes contracts?
Apply, well, I'll tell you the whole story if you want. Either the Maryland mechanics lien statute has to apply or the Maryland payment bond statute has to apply. And I have one of the leading recorded cases on this in Maryland, the Jaguar case, which unfortunately we were on the losing end of the argument, although we resolved the case pretty well on other grounds later. But the federal court in Maryland ruled that since we did not have mechanics lien rights because it was a federal project, we also did not have Maryland Trust Fund statute rights. And that's an example where that might happen. Or I don't know if you, well, this afternoon we'll talk about the 15% rule, the 25% rule. You don't have mechanics lien rights for small construction projects. If you don't have mechanics lien rights, you also don't have trust fund rights. So that is the answer. You have trust fund rights on any construction project where there's either mechanics lien rights or public payment bond rights, not private bond rights. Okay, I'll tell you what used to be a true story. I had sweetheart wills with my wife. Those are the types of wills that say if she dies, I get everything. If I die, she gets everything. If we both die, if we go down together, then everything we own will go to my brother, Larry, as trustee for the benefit of my children. And that's not a true story anymore because my baby's 32, but I guess there's still a trust. But anyway, so let's say that my wife and I went down in a plane back in the early 1980s when our kids were little. And so my brother received a big hunk of money, all the money we had, and he uses some of that money to take them to the Bahamas every spring, and he uses that money to pay for their school and to pay part of his mortgage, and he can write a check on that trust account anytime he wants. But let's say he's in the construction business and he supplied a couple of the wrong people on a couple of the wrong projects, and he's now insolvent, and he files personal bankruptcy. And some of his creditors say, wait a minute, you're the only signator on this bank account over here that's got a couple $100,000 in it, and you write checks all the time to go to the Bahamas and to pay your mortgage. I'm going to garnish that bank account. Does that work? Everybody's got the right answer. No, that doesn't work. Why not? It's in trust. It's not the trustee's money. That's the legal concept. The trustee holds mere legal title. It doesn't belong to the trustee. The money belongs to my children, the beneficiaries. They are the owners. And the trustee holds mere legal title. So the creditors of the trustee cannot pursue that. And if you think about it, by the same token, my brother could not grant anybody a security interest in that bank account because he doesn't own the money. The beneficiaries would have to do that. Beneficiaries and the trustee is what would have to happen. So, where this becomes critically important, a trust fund agreement or a trust fund statute becomes critically important in the event of bankruptcy. As a matter of fact, we mentioned bankruptcy preference litigation early, which we do a lot of. If you were operating on a Maryland construction project at the time, and now it's 3 years later and you're being sued for this $100,000 preference, the check you received 60 days before the debtor filed bankruptcy, the first thing I'm going to look at is whether the Maryland Trust Fund statute applies. And the way trustees are, your short lecture on preferences is they just sue the bank book. They sue the bank. Everybody who received a check in the 90 days prior to the bankruptcy is going to get sued. They do not evaluate at all whether it's a bankruptcy preference. They just sue you, and they leave it up to you and your lawyer to prove that it's not, because they write their own legal fees. They control their own budgets. The trustee can, and he hires his own firm to do all this litigation. It's really kind of a shame, but that's what happens. And so if you get sued on a project in Maryland, the first thing I'm going to do is look whether the Maryland Trust Fund statute applied. If it did, think about it. That's a simple case. When the debtor, when this general contractor gave me the money, he was giving me my own money. He was holding that money purely as a trustee. He had mere legal title. It was always my money, so I did not receive part of the bankruptcy estate when I received that check. It was never a part of the bankruptcy estate. Okay? And you'd come to the same result, or when people do file bankruptcy, maybe you're owed money, and you got to be pretty quick about this. Early in a bankruptcy, the debtor's saying, we need our bank accounts to make payroll. Judge, give us the right to use our money. And there's usually a bank who has a security interest in all the bank accounts. So they got to bring the bank into court, and they say, well, we have a security interest in that bank account. No, you can't use that for payroll. And the debtor's like, well, then I'm out of business. And if I'm allowed to stay in business, I'm going to make more money. I'm going to come out of this bankruptcy okay, and I'm going to pay everybody. That's the way the conversation almost always goes in a Chapter 11. So the bank requires a super priority, security interest in all of the assets of the debtor in exchange with their agreement to let the debtor use the bank account for payroll. And it becomes very important for me to be able to show up right at that juncture of the bankruptcy and say, well, wait a minute, y'all are having a nice party here talking about this money, but it's not the debtor's money. The Maryland Trust Fund statute applies, or I have a trust agreement in the contract with the debtor, and at $70,000 in that bank account is mine. And the debtor was powerless to grant a security interest in all of those funds. And the debtor was powerless to give the bank an interest. The debtor's powerless to use it for payroll. That's my money. Give it to me. Pretty powerful stuff, right? All right. You can have tracing issues. You have what you call the lowest intermediate balance test, that if the bank account ever went to zero, if you think about it, the law would look at that and say, well, the trustee breached the trust. The money went out of the trust. But as long as there's always at least 70 grand in that bank account, and you can say, and you can show, look, they received 70 grand on this construction project on this day, and there's been 70 grand in the bank account ever since, that's my money, that works. But if the account ever went to 20 grand, the trustee only kept the trust for that 20 grand. All right. It will beat bankruptcy. It will beat secured creditors. You can put a trust fund agreement in your contracts. You can put it in your joint check agreements. You can put it in your subcontract. You might remember the joint check agreement appendix we were looking at early on. I was telling it, it's called a project trust agreement. That's the mechanism that's set up there. There's no such thing as a standard joint check agreement. They vary widely in how they're worded. A true joint check agreement is another unsecured contract of a type. You want it to be more of a security agreement of some type, or a trust. If you're a creditor, you do. And one way you can do that is by putting a trust fund agreement in the joint check agreement, that the GC is going to hold the funds in trust for you on receipt of that check. Okay. So maybe that's a good time to take a break. We're going to switch to reviewing contracts that other people write and send to you